So I will start English as we have a guest from Germany. So the first session will be in English, apparently. But if you have any questions, you can ask your questions in Turkish, so we'll translate, okay? We don't have, apparently, a simultaneous translation, but I hope that you will understand his presentation. We already sent his presentation. I would like to welcome first Professor Thomas Weck. He's from Frankfurt School of Management and Finance. It's not a law, actually, right? It's not a law school. You don't have a law school. It's a business school, yes. And I think I've been there, and it is financed by the industry a lot, because Frankfurt is known with financial center. It's financial center, so a lot of firms actually funding that institution. Am I right?
That's right. Yeah.
Yes, I remember correctly.
It's a private firm, private school.
Private school, and it's very rare for Germany.
Yes.
So there are only a limited number of private foundations. As in Turkey, we have a lot, right? So, but none of them is private anymore. Okay, so I'd like to welcome Professor Weck. Thank you for coming here. It will be a pleasure to listen to you today. He will talk about the digital markets, and he will talk about Germany, what has happened in Germany. It's one of the first jurisdictions which actually amended their laws in order to cope with the problem of digital markets, and he will compare the German solution with DMA, I think, in his presentation. Let me introduce him to you first, before giving him the floor. Professor Thomas Weck is an associate professor for public law, regulatory law, and comparative law. Until joining Frankfurt School, he was lead analyst at the Monopolies Commission in Bonn. So it's equivalent of our competition authority, sort of, right? Yeah, because you have two, right?
We have two indeed, yes. The Monopolies Commission is actually the weirder one, because it was installed just to monitor the concentration development, basically. Out of this, it has developed into some kind of advisory role for our government and parliament, but it's not involved in on-the-ground enforcement. That's the Federal Cartel Office.
Yes, yeah. Okay. So he was lead analyst at the Monopolies Commission between 2012 and 2022, and previously worked at a British and American law firm in Brussels from 2007 to 2012. At the Monopolies Commission, he focused on issues of competition law and regulatory law. While working there, he habilitated on regulation of innovative financial instruments, risk as an objective supervisory law. Professor Weck is co-chair of the German chapter of the Ascola and a member of, okay, this is German, Wissenschaftliche Vereinigung für das gesamte... All right. The last word, I couldn't do it. And a member of Association of Friends of the Baden-Württemberg Foundation. Today he's going to be with us with competition law and digital markets, the EU and German approaches. I'd like to thank him again for coming here. It's a pleasure to have you again. And you have the floor. You have 30 minutes or 35 minutes, we can say, or even more, since you're coming from Germany.
30 minutes is
all right. Thank you.
Yeah, thank you, Professor Sandy, and also thanks a lot to your team for organizing this wonderful series, and also my very pleasant stay here. So far, I'm thrilled to introduce you to our thoughts at the moment of where we are standing with competition law and digital markets. You'll see that the rule sets I'm going to talk about are much intertwined, but I'll keep it not too detailed, so that everyone should be able to follow. There will be, however, some more recent developments and things for those of you that are interested in following those trends. So, digital markets. Digital technologies shape more and more markets, and this is not by accident. Data reduce information problems. They also reduce transaction cost. This means that market failures can be overcome and markets become more efficient. Hence, digitalization is a welcome phenomenon from a competition policy perspective. However, where digital technologies have transformed markets, competition law has fallen short of protecting the openness of those markets. The view in the EU is that this is not by accident either. Rather, it is a likely consequence of digitalization. Digitalization allows companies to amass and use large amounts of data. In this context, a key role must be attributed to online platforms. Online platforms are information and transaction intermediaries. They act as intermediaries between user groups. They offer their services to different user groups in parallel. And they allow users to interact directly on the platform infrastructure. The intermediary position makes online platforms a go-to infrastructure, particularly for services distributed to consumers. Network effects arise because the more users, for instance, a social network has, the more it becomes attractive to additional users. The more buyers an online marketplace has, the more attractive it becomes to sellers. Network effects, however, also arise in the sense that the intermediary can collect data from the transactions effected via the platform infrastructure. It can use those data to improve its services and attract more users, or to monetize the services via online ads. Thus, data-driven network effects allow platforms to grow and expand their service portfolio. Network effects, economies of scale, and economies of scope are efficiencies, so they are welcome. But the particularity of the platform economy is that combining those efficiencies can make users depend on the services of certain online platforms. The particularity of the platform economy is that combining network effects, economies of scale and scope can make users depend on the services of certain online platforms. And that is more problematic. Think, for example, of Google Search or the Apple App Store. The dependency of users in turn means that platforms may be in a position that cannot be contested anymore. The market tips permanently. If intermediaries continue to expand by adding complementary and compatible services to their core platform services, whole digital ecosystems emerge. Here, it gets even more challenging for rivals to snatch away users in competition. And this is why Google, Apple, Meta, Amazon, and Microsoft became the undisputed incumbents in the EU's online economy over time, challenged only by Chinese firm ByteDance with TikTok. Market tipping and digital ecosystems don't align well with traditional competition enforcement. Where the market falls for one service provider and the others leave the market, there is simply no one left to take up the competition after a finding of abusive behavior. And markets may tip faster than the time it takes for an investigation in the digital sector. Thus, by the late 2010s, a debate arose whether we need a new toolkit to intervene even before the market structure is damaged irreparably. This is the reason why the EU passed its Digital Markets Act in 2022 and why Germany incorporated Section 19a into its Competition Act. The two were interrelated from the beginning, but they follow different philosophies. The European Commission pushed forward with the DMA when Germany had announced plans to amend its Competition Act. The reason was that such national legislation might fragment the EU internal market. The DMA, however, is not competition law. Instead, the impact assessment accompanying the legislative proposal revealed that this regulation was aimed at remedying market failure. Thus, EU legislature assumes that competition law should protect functioning markets against abusive behavior. In contrast, the DMA is intended to apply where digital markets are not functioning freely anymore for structural reasons due to the presence of large online platforms. Section 19a entered into force shortly after the Commission had published the DMA proposal. Section 19a includes conduct obligations similar to those in the DMA, and German legislature, in fact, took the DMA as a model in this regard. However, Section 19a is part of the Competition Act. Thus, it is competition law. And the Federal Cartel Office, or FCO, Germany's competition agency, also has applied it like competition law so far. That is, it has used the provision to react to market developments ex post, not to shape markets ex ante. In comparison, the DMA is different. This slide provides an overview contrasting the key features of the two legislative approaches. However, I included this overview in my slide deck only for your reference. This presentation is going to be distributed?
Yes.
Perfect.
If not, maybe we have already shared, yeah.
Okay, so it can be shared freely in any event. So there you may take a look at this slide. In this oral presentation, however, I'd rather like to take a deep dive, so not stay with the overview. Let's focus on the DMA first. As said before, the DMA is about market failure. It intervenes by law where platform markets have tipped, where, as a consequence, users have become dependent on individual online platforms and where competition, thus, risks being eliminated permanently. That is to say, the DMA is about bilateral fairness and contestability in the internal market. It's not about competition in general terms. As regulation, the DMA adopts a very formal approach to things. Norm addressees are formally designated as gatekeepers. The designation is generally based on presumptions related to size and without an assessment of individual circumstances. The DMA subjects designated gatekeepers to predefined conduct and transparency obligations. These include prohibitions to combine data or platform services and positive obligations to provide access to data and allow switching between services. The obligations apply across markets. That is, the situation on individual markets is irrelevant. Moreover, The obligations are meant to open up markets without any individual assessment of existing conduct. There is no balancing of anti- and pro-competitive market effects. Finally, the DMA centralizes enforcement with the EU Commission. This is intended to speed up things and to entrust enforcement of big tech rules to a powerful regulator. An interesting novelty of the DMA is how it aims to ensure compliance. The first layer are obviously the legal conduct obligations. But the DMA does not only prescribe the conduct as such. It also obliges gatekeepers to show effective and ongoing compliance and to prove it. The implementation of the obligations is supervised by the Commission, which can use an unregulated informal dialogue to specify the measures that gatekeepers should implement to ensure compliance. Whereas this first layer of obligations shifts the compliance burden broadly to the gatekeepers, the second layer kicks in if they try to circumvent the rules. In such case, an anti-circumvention provision allows to find non-compliance and to take redressive measures. A third layer is governance-related. Gatekeepers are obliged to install an internal compliance function. They also have to report on the measures adopted to ensure compliance. The fourth layer are sanctions if gatekeepers don't comply. We see here the DMA is not just regulation. It is actually a new type of market regulation. Section 19a of the German Competition Act looks a bit similar, definitely. However, it is different. As noted before, Section 19a is competition law. It is essentially a special abuse provision. However, it has some regulatory aspects to it. Notably, Section 19a too requires a designation of norm addressees. This designation, however, is based on an individual assessment and decision by the Federal Cartel Office. The FCO must find paramount significance across markets. Still, the designation serves somewhat similar functions to the one under the DMA. It is company-wide and can also be used to impose and enforce conduct obligations. As said before, those conduct obligations in Section 19a were actually modeled on the ones in the DMA. However, Section 19a requires an individual assessment whether those obligations are warranted, and it allows designated companies to avoid FCO orders based on an efficiency defense. The challenge is to decide when the DMA and when Section 19a is applicable. Legally speaking, the DMA has primacy of application because it is EU law. However, the DMA itself acknowledges that it does not cover everything. Consequently, it leaves open the door to apply Section 19a whenever the FCO targets other companies than DMA gatekeepers, if the FCO imposes rules on other services than DMA core platform services, or at least arguably, if it imposes obligations to address abusive effects that the DMA cannot prevent with its own conduct obligations. At the same time, both rule sets are part of an overarching institutional framework. In this framework, the European competition agencies cooperate, and both EU courts and national courts share the power to review agency decisions. At this point, it appears that the two rule sets are working alongside in practice quite well, although legal tensions remain. Let's take a closer look at this interplay. The first thing to note is that the same firms were designated under both the DMA and Section 19A. This is true at least to the extent we're talking about US big tech firms. The DMA is enforced also towards Booking and ByteDance, that is, a European and a Chinese firm. However, enforcement action, including non-compliance decisions, has centered on US firms so far. The designation criteria under the DMA and Section 19A are similar. This does not follow from the legal wording directly. Notably, Section 19A mentions criteria also indicating market power. In practice, and in line with the legislative materials, however, the FCO focuses on elements indicating cross-market power. For instance, the potential for users to save cost by sourcing services in bundle, or the platform operator's economies of scope. An important difference: the DMA includes presumptions which must be rebutted by potential gatekeepers. In contrast, German law places the burden of proving paramount cross-market significance on the FCO. Now let's take a closer look how the conduct obligations work in practice under both the DMA and Section 19A. A first practice example highlights the possible legal tensions between the two regimes. I'm talking about Apple's App Tracking Transparency, or ATT framework here. Since its introduction in April 2021, app providers in the Apple App Store must obtain additional user consent before they, as developers, can access certain data for advertising purposes. These requirements do not apply to Apple itself, however. Apple obtains broad consent for all its data processing already when users first enter Apple's digital ecosystem. The FCO sent a warning letter to Apple in February 2025. In this letter, the FCO set out its concerns that the contractual conditions of the ATT framework might harm developers and advertisers, justifying intervention under general abuse rules and under Section 19A. The French Autorité de la Concurrence, just 1 month later, in March 2025, even imposed a fine of 150 million euros on Apple. The French authority shared the FCO's concerns. Moreover, it noted that the consent query for Apple's own applications differed from the one displayed for third-party apps. The entire practice amounted to abusive self-preferencing in the authority's view. However, Apple is also a designated DMA gatekeeper for its App Store. Thus, in April 2025, the EU Commission imposed a fine of 500 million euros on Apple. In the Commission's view, Apple was violating the so-called anti-steering obligations of the DMA. Note that the Commission here formally relied on the designation of the App Store whereas the FCO assessed Apple's terms and conditions, and the Autorité applied traditional abuse rules. However, the underlying facts obviously overlap to a large extent. That said, my second example shows overlaps don't have to exist. The complementary nature of Section 19a plays out where different undertakings or services are being targeted by the DMA and the national rules. Here, I'd like to focus on the enforcement in relation to Google. Regarding the DMA, I chose one of the first civil court actions under this Act. This example illustrates that the DMA has potential also beyond the regulatory enforcement for which the Act was designed originally. In August 2025, the Lower Regional Court of Mainz in Germany decided on a civil action brought by 1&1, 1&1, an email service provider. 1&1 claimed that Google was violating the anti-bundling provisions of the DMA. Google required users to authenticate themselves using a Gmail account if they wanted to register for services such as Android, Google Play, Chrome, or YouTube. The court noted that Google had been designated as a gatekeeper for the Android operating system and that also Gmail reached the designation threshold. Thus, bundling of the two services was prohibited under the DMA. Google certainly claimed efficiencies, but unsuccessfully. Moreover, it argued that user identification by Gmail was deeply integrated in its IT systems. Now, we know already that efficiencies are irrelevant under the DMA. Regarding this second claim, the court noted that identifying users via a Gmail address internally did not mean that Google had to foreclose rivals when it came to the provision of email services. The FCO likewise has investigated Google's bundling practices under Section 19a already. Two interrelated investigations concerned Google Automotive Services and Google Maps. Both services had not been designated under the DMA so far. Regarding automotive services, the FCO uttered concerns due to the bundling of Google Maps, Google Play, and Google Assistant. Regarding Maps, it took issue with Google's practice of restricting the combination of Google Maps with services from other providers. These investigations were concluded by Google agreeing to allow the free choice of services from other providers and ensure interoperability in the future. Here, however, there is obviously no conflict with the DMA, and no such conflict also arose in practice over time. Please note, however, a little error on the slide. That's down here. Only the FCO investigations ended with commitments. In the Lower Regional Court of Mainz case, the court ruled by judgment that Google must end the exclusive use of Gmail when users register for its services. Google simply has not appealed the judgment, to my knowledge. I stressed that the DMA is regulation. For a complete picture, one should also consider the interplay between the DMA and other EU rules. These EU rules include not only competition law, but also notably the Digital Services Act, which imposes compliance obligations with regard to illegal content. Data protection and data sharing rules and the AI Act recently enacted in 2025 are relevant as well. Thus, for quite a while, Europe has been creating a comprehensive rule book for the digital economy. in this rule book, competition policy, data protection, and platform responsibility are increasingly intertwined. But how are things going to develop in the future? In fact, next steps have already been defined in the existing regulation, or can at least be inferred from enforcement practice. Thus, when it comes to the DMA, the constant challenge is to adapt its rigid rules to market evolution. A formal review is foreseen for this year, and this review is definitely welcome. Although the DMA was only enacted in 2022, it did not account properly for important market developments that are currently in the focus of discussion, notably artificial intelligence and its backbone tech stack, including cloud services. Particularly the use of large language models for online searches may require at least some clarifications. Regarding enforcement at national level, the German FCO remains in a strong position for the time being. Not only has it established itself as an alert and daring regulator of international repute, but legislature has also complemented its regulatory arsenal beyond Section 19a. Section 32F, a provision not yet used in the digital sector, allows the FCO to impose even structural measures on firms with paramount cross-market significance. Finally, traditional competition law remains important as well. This is because both the DMA and Section 19a, as such, only empower authorities to regulate the conduct of designated firms. Besides, this is also true where these rules allow for structural remedies. The remedies are meant only to ensure compliance with the conduct obligations. Thus, those rules cannot be used to restore a competitive market structure as such. The new FCO powers under Section 32F complement the ex-ante regulatory framework, but they are not intended to remedy past abuses either. With this, let me sum up the key takeaways. Firstly, a hybrid system combining ex-ante regulation and ex-post competition law enforcement is the new standard for dealing with the digital sector in the EU. Secondly, the DMA and Section 19a serve largely complementary functions in practice. That does not exclude conflicts, but the interplay works quite well overall. Thirdly, we can be confident that designated firms will implement their obligations. Different from some other jurisdictions around the globe, there is no indication that gatekeepers are poised to simply ignore the demands of regulators in the EU. Please note, however, that this is not to mean that I subscribe to the regulatory approach of the DMA or Section 19a. In my personal view, the DMA leaves the competitive significance of existing digital ecosystems largely untouched. This is because data use across services is only made more difficult, but it is not prohibited completely. Section 19a raises constitutional questions. Yet, fourthly, the regulatory landscape is dynamic. We've already witnessed new market developments with the rise of AI. In addition, enforcement action and court review will increase our understanding of how digital business models evolve and what this means for market development in more general terms. I come to the end of my presentation and thank you very much for your attention.
Well, thank you, Professor Weck, for your clear and very informative presentation. And I have some questions, but before that, I turn to the audience and asking whether you have any questions here. As always, Armanç has a question. But first, before Armanç, is there anyone else who wants to ask something? Is there anyone else? Deniz? Okay. We have.
So, Professor, thank you for your presentation. So, as you mentioned in your presentation, in German competition law, undertakings has objective justification defense possibility. So, I'm curious about has this defense has ever been used by undertakings? And if so, the competition authority make assessment. How make their assessment about this defense?
Yeah, thank you very much for this question. It's obviously an important one because here we are talking basically about the juncture where Section 19A is still related and based on competition law, but obviously where we also need to take into account this cross-market aspect, which is different from traditional competition law. Well, to my knowledge, Section 19A, A's efficiency defense has been raised already, but there is no decision where it was successfully raised. However, we must see that we are still at an early stage of enforcement. The enforcement of Section 19A is particularly tedious. This is because companies, it's a two-step procedure, right? Companies first need to be designated, and then you can impose those conduct obligations. Now, we had the first challenges to the designation only last year solved, and I think there may be even one case still pending. And only then the FCO is able to then start, impose those conduct obligations. So this may at least partially explain why we haven't seen anything on the competition, on the efficiency defense yet. But another factor is obviously if companies just, agree to the FCO's demands to get the case done and solved. And this is also something that can happen under Section 19A.
So thank you very much.
Thank you very much. Any other question? All right.
Many thanks for the presentation. My question comes from rather an existential place. You've given us a very good picture, but I'd like to maybe hear your thoughts about the differences in approach when it comes to digital services and digital markets between the EU and US. And this comes from maybe an innovation protection perspective. The EU seems to have a more rigid approach, although we're looking at not only a regulation, but also an ecosystem of regulations with a lot of leeways and no backup scenarios. It still seems to me a little bit rigid and not maybe capable of keeping pace with the rapid, exchange rate of the digital services in the technology. And when it comes to US, they seem to have more like a move fast and break things kind of approach. Where would you place EU on this scale, and what would you correct if you had the chance within this regulatory ecosystem?
Yep. Thank you. Another important question. Obviously, now we open basically the perspectives to also make the comparison to the US. Honestly, I cannot provide a good answer, I think. The US certainly has a more flexible system in that it does not regulate that much. However, we must also see that, at least from the European perspective, there had been at least 1 decade of under-enforcement, right? When the first cases were brought in the EU, in the US there was nothing. And now we see that litigation is arising where US agencies bring claims against EU gatekeepers, big tech firms, and where those claims actually resemble very much cases that we had already in the EU, right? So the same concerns that exist in the EU are now triggering litigation in the US. But litigation in the US has its benefits. Yeah, it's case specific and it can take account of market developments. It's adaptable, but it's also very slow. And cases can be settled, as we also have seen in the US, which means that it's then unclear basically what the case is about to tell us, right? Still, I already said that I'm not in favor very much of the EU system either, and there I'm completely with you. The EU system is very rigid, and we see this with the DMA. The DMA may cover something like ChatGPT, even though it didn't exist at the time the DMA was enacted, because the definition of search, online search, also covers search functions that produce direct answers. And this is what ChatGPT basically does, right? However, there can be other developments that we cannot capture that much. And as I said, when it comes to the entire AI stack, the entire interrelated stack of technologies, energy, talent, and so on that's relevant for AI, I don't know whether the DMA is sufficient. Now, at the end of your question, you also asked what I would correct if I had the chance, right? And there I also presented already in 1 sentence a solution that I think is at least worth discussing. And that's basically how we handle the cross-use, the combination and cross-use of data. Because in the beginning of my presentation, I said we're talking about efficiencies, right? Those digital ecosystems, big tech firms, they are hugely efficient. They are really wonderful when it comes to providing services to consumers. Consumers are always happy, and for a reason. They are the best to provide those services. That's why consumers flock to those service providers. But at the same time, those efficiencies can turn into lock-in effects. Think of it. Would you switch to Bing, for example, for online search? Now you may say, well, Google is just better, right? So I stay with Google. But who has the data of past search queries? It's obviously Google. And this is why Google is better. And this creates a lock-in effect, obviously, right? You cannot switch to Bing. It doesn't make sense. Yeah? And this power derived from the data can be used to add always step-by-step compatible and complementary services to this platform and to create this digital ecosystem. But the more services you add, the harder it gets also to challenge the incumbent on its core platform services, right? Because now we're not talking about an individual service. We're talking about a whole service portfolio. If you use Google, you also use Maps. You use Google's, I don't know, restaurant search or other services, right? So all of this has to be seen together. And the other question is really, should we allow big tech firms to combine data the way they are combining the data, right? Taking into account, if we prohibit it, we first destroy the business model to a large extent, and second, we take away those efficiencies, right? That's a tough question, really, to answer.
It doesn't seem good for the consumer, at least, if we prohibit that. So there's real problem there.
Yeah,
Yeah, but yeah.
completely agree.
Yeah. Okay.
Thank you for the presentation. I want to ask a little bit more broad perspective question. What do you think about the ongoing debate about the European Union favors European companies in competition law against mainly United States? And with the new merger guidelines is on review, and they state they want to easy up for European companies to get merged and reach the scale. What do you think? This is a positive change in European Union fairness and in global competition? I'd very like to hear your thoughts about that. Thank you very much.
Now we have a political question.
Yes, I'll try to answer it as a lawyer, though. So, first question is obvious. Answer is obviously to say it depends. I don't know whether this answer helps in this context, but I would say it depends on really whether we are talking about big tech platforms and merger control. When it comes to big tech platforms, I honestly don't subscribe to those suspicions that EU law is targeting US firms specifically. US big tech firms are the most prominent examples of DMA gatekeepers. However, well, they are also the biggest service providers on the internet, right? I mean, there's no way avoiding designating those firms. We may question whether Booking had to be designated actually. Probably I have not looked into the designation decision specifically, but well, one may think, well, they don't provide much more than a hotel booking service, so they are not the prime target of the DMA. So we could even have excluded Booking, perhaps, but it's in. And but I think in general terms, the EU is agnostic when it comes to DMA enforcement, simply because we are talking about firms that are so huge, such behemoths, that basically there is a justification for thinking about regulation anyway, whether they are European or non-European. The only question then is whether the DMA is good regulation, and we discussed that already. When it comes to merger control, the answer is a bit more difficult, because here we are also talking about whom do we want to invest in Europe, right? So it's not just about firms coming in from the outside and basically us protecting against those firms. But it's also about making sure that we avoid creating additional dependencies. That is not anything the DMA is about. The DMA is just about, it's a bit about dependency in the bilateral relationship, but this is not the dependency I'm meaning here. The DMA is about essentially making markets work again. And when it comes to merger control, we need to think about, okay, if, for example, knowledge is acquired by outside acquirers and then leaves the EU, we may become additionally dependent on other countries, right? Other jurisdictions. And this may be factored in, actually, because here we are not just talking about competition law, we're talking about external trade, right? And external trade follows slightly different rules. There it's not just about the level playing field, but it's also about making sure that we have a balanced relationship to the outside, right? So whenever merger control is applied to prevent that we enter into permanent dependencies that cannot be broken up by normal competition anymore, then I would say we may have an argument for merger control to apply and prevent those merger transactions that create the dependencies. But obviously, that is all I can say as a lawyer, and even if I go beyond, then it's political, so I stop here.
Thank you very much. Well, It's already 8:15 now. It's better to, end the session. Thank you very much, Professor Weck, for your nice presentation.
Yeah, thank you all for the questions. Now we have 15 minutes break.